Yes, yeah, no, no, I have, and I had to summarize. Okay, so there's two not so well known halachot relating to business and business dealings, and the first one is called ona devarim, which is basically causing people distress through words, and it says here you're not allowed to cause people emotional distress by psychologically taking advantage of them in business dealings. And the example that they give here is let's say I'm a used car salesman and somebody comes to the dealership and he wants to buy well, a new second-hand car. And I say to him, your car's garbage, it's trash. Get rid of it immediately or so I force him to sell, even though there's nothing wrong with it. So that's basically it's not ethical behavior, and it's what's the word? It's duress. It's basically putting pressure on him. And unfortunately, this does happen, as we know, but you're not allowed to do that. And okay, pretty simple example. And the second one is lifnei iver, and lifnei iver is when you could do a certain action which may be um, uh, patur, may be allowed in Judaism, but it could be also forbidden. And the example that they give is someone that builds a non-kosher restaurant or kitchen in Israel to facilitate non-kosher food. Now, there are places, unfortunately, like this that exist, but you may unwittingly, Jews might consume this food thinking that it's kosher. So one should try and avoid controversial things like this. If you're aiming it towards the Filipinos or the Asian or the East African economic migrants or contract workers, then that's fine. Maybe there would be an allowance for that, but not stum just to open such an establishment.
Good, Kev. Sorry, we're in a bit of a flying rush. I'm going to share the screen, and I actually want Gavin Stoller to read because, Gavin, I think you need all the brocha you can get. Just give me a second. Gav, you want to read it for us? You read well. I can't hear you.
Sorry, I was just putting on my glasses. Yeah, I'll read with pleasure. Thank you. The final Mishnah of this chapter concludes with some general rules relating to court procedures. If a person was sentenced and he escaped before the court could execute him, and he then came before the very same court which had originally sentenced him, they do not reconsider his sentence but carry out the previous sentence immediately. Wherever two stand up and declare, we testify about the person that he was sentenced in so and so's court, and so and so and so and so were his witnesses, he is executed. The law of Sanhedrin applies both in the Holy Land and outside the Holy Land. A Sanhedrin that executes once in 7 years is called a destroyer. R. Eliezer ben Azariah says even once in 70 years. R. Tarfon and Rabbi Akiva says, had he been on a Sanhedrin at the time when they still performed executions, no person would ever have been executed. Rabban Shimon ben Gamliel says they too would have increased the number of murderers in Israel because they would have eliminated the criminal's fear of retribution.
Perfect. Okay, so just a couple of quick notes. On the second law concerning a fugitive, whenever two witnesses stand up and declare we testify against such and such a person that he was sentenced to die in so and so's court, and so and so and so and so were his witnesses, um, the defendant is executed, but there is a caveat there. The whole reason why they must add specificity to their testimony in another court, such as the time, the date, the place, the first witnesses said they saw the accused commit his crime, is based on Sanhedrin 43a. Gavin, you remember it with Rav Simcha Steinhauer, that there was this whole thing that they'd let out the accused just before his execution, and they say, can anybody testify against the first set of witnesses in case they happen to be Zomamim, conspiring witnesses? So, in other words, we need specificity in order to check if the set of witnesses that come to a new court against the defendant are lying. And that's why we can only testify, they can only testify against the defendant as per the standard rules if they've got skin in the game, and they can seek to get the death penalty enforced upon them should they be plotting. Okay? So that's pretty straightforward. Now, there's this issue of obviously 23 judges, both in the Holy Land and outside the Holy Land. Just want to bring something to your attention, is that you have to, in order to be ordained on the Sanhedrin, we'd already discussed there had to be a language proficiency in multiple languages of the time, but the classical smicha could only be given in Eretz Israel. So judges who received that sort of smicha could judge even outside the land of Israel. And they could also judge capital cases as long as the great Sanhedrin still sat in the Holy Land and the temple was going. So that's pretty obvious. As far as any other detail is concerned, I think, yeah, I think the only thing that you've got to bear in mind is that you have to know that the court always has to seek ways of exonerating the defendant. And when the procedure is adhered to, executions are rare. This is the whole premise of how the Mishnah ends. So if a court executes too frequently, according to some opinions, 1 in 7 years, according to a more realistic interpretation, as the generations got worse, is 1 in 70 years is rare. 1 in 7 years is probably more realistic. So what happens is if the judges are aware of the intricacies of capital judgment in cases, they can, in a way, provide a defense for the defendant. So therefore, why does it get this title of the destroyer? And it's mentioned in the Ein Yaakov, is because it means they haven't worked hard enough to apply their minds laterally to get the defendant off. However, if the evidence is strong enough, then the court has no problem convicting and executing, even if there's multiple deaths on one day. There's no blame that attaches to it. So that's the only thing that I wanted to bring to your attention. So let's get straight into it. Now,
isn't it considered cruel if it does that? Cruel. I thought they would destroy. I thought it was considered cruel if it executed, not the word destroyer.
Well, when they say destroyer,
what
what they mean is the destroyer of a person's life. They mean that they've got blood on their hands. So what's deemed as having blood on your hands is spillers of blood in Israel, as the Mishnah says, is that it was unnecessary for the person to die. But they don't all hold by that opinion, because Rabbi Shimon ben Gamliel said, yeah, it's all very well getting the defendant off, but then there's no fear of retribution because they know that the Sanhedrin is going to do everything to get them off, and the people are at risk in general. So it's not that, in fact, he was strict. He was thinking of the macrocosmic effect that it would have on the population as a deterrent, and that a population wouldn't be put at risk, Kevin. That's the major issue. So I just want to bring something to your attention, guys. The Gemara starts off and it says, look, there seems to be a contradiction. Because when you look at the Mishnah's first statement, it said that if they recaptured the defendant, no defendant would in his right mind go back to the court and say, listen, I was convicted in another court, unless he's got a death wish. So he was obviously captured by the policing force or the military force that the country had at the time. And if he came before the exact same court, they don't reconsider his sentence. because they're convicted in the first time, they're aware of the entire matter. But the implication there is if it came before a different court, they would consider it. They would reconsider the matter because it would be a new opportunity to get the defendant off. But then there seems a bit of a confusion because the end of the section of the Mishnah teaches whenever two stand up and declare, we testify against such and such a person in this court, and he was sentenced to die. In a different court, these were the witnesses. This is when they saw the crime. This is when they testified. This is what they said happened, etc. Then it seems that if the defendant had escaped, but he comes before a different court, he's still executed without a retrial. So what's the question? Because it seems to be why make a statement saying they don't reconsider it in the same court? Because then it's implicit that they do reconsider it if it came before a different court. But then when you say you've got two witnesses that come and testify in a different court and say, hey, there was this defendant. I know which apartment block he's staying in, and this is what transpired in this particular court, and these were the witnesses against him, and these were the details of the matter. And we don't mind if you check out the facts because we don't want to die as Adam Zimmerman. Then the Gemara is basically saying, well, then what's the point of putting it to a different court if he's still executed without a retrial on this basis? So according to Abaye, there's no particular difficulty. What Abaye is saying is that in the first statement, we have to speak of a court that was located in Eretz Israel. In that case, it's considered that if he has to go to court outside of Eretz Israel, his sentence isn't considered because Eretz Israel is known as the highest judiciary in the world. So therefore, if he escaped to Babylon, and it's a different court, they don't retry his case. But if he escaped to a different court in Eretz Israel, we're going to see what happens. So Abaye says, look, it's pretty clear. If you look at a particular brisa, there's a rationale behind it. According to Rav Yehuda ben Dostaya, it says in the name of Rabbi Shimon ben Petach, if he actually escaped from the Holy Land to outside the Holy Land, and then he came before a court where there were witnesses that testified that he'd actually been sentenced to death in a court in Eretz Israel, they don't reconsider his sentence. But it does work to his favor, it's the other way around. In other words, if he escaped from Babylonia and he ran to the Holy Land, they actually do reconsider his sentence. What do you think the reason could be, guys? Anybody?
Is the Beth Din or the different between in Israel and outside Israel?
That's a question. Do you have a suggestion? It's the question.
Maybe they have more merciful inside Israel.
No. So basically,
jurisdiction.
So Kevin did bring a point that there are jurisdictional matters, but basically, according to the explanation, the first part of the Mishnah is specifically discussing a case in which the first trial took place outside of Eretz Israel. And now the defendant is brought before a court inside of Israel. So therefore, if that was the same court that was in the diaspora, but it just happened to change jurisdiction, Kevin, and it relocated to the Holy Land, but it was the same judges presiding and they had the same case details, it would not be reconsidered. But if he's recaptured from Babylon in Eretz Israel, he is granted a retrial because there's an extra merit of the Holy Land, and that will cause maybe new judges to find reasons for acquittal. They might be given, not if it's the same judges and they've reconvened because it's a vassal state and political situation, but if it's a new court, that there is some holiness that can provide for them to have Ruach HaKodesh or lateral thinking for an acquittal. But it's certainly that extra merit of it being out of Israel to Eretz Israel doesn't work with the same court. It's only if it's a different court. So now, just to add to the complication, the second half of the Mishnah is discussing a case in which the court before whom the witnesses testified was actually located outside of Eretz Israel. So regardless of whether the first trial took place inside or outside, since the defendant does not have to discredit the merit of Eretz Israel, we've got no reason to expect a different result, even from a new court. So in that case, if both of them took place outside of Eretz Israel, and he was apprehended and taken to a new court because the defendants have said this is what happened in a court in Babylonia, and this is what they caught him in Greece, and they've got no reason to retry as long as those witnesses are prepared to go through the Adim Zomamim treatment should they be found out to be conspiring. Okay, so only in certain cases is the merit of Eretz Israel can assist a loophole to exonerate him. Does everybody understand that? Any questions before we go on?
Yeah, maybe just a question. Sorry, James.
Yeah.
Do you think it was a matter of like holiness and more merits inside Israel, or perhaps maybe, I don't want to say anything bad, but maybe they thought they were more superior to the people in diaspora, and they had the superior knowledge, and it wasn't necessarily a holiness issue. It was more like, well, a little bit better than you guys.
So I agree with you on both counts, is that the Gemara mentions both reasons, both here and in Sanhedrin. And the one thing of it is that, do you remember, Gavin, when we were learning Sanhedrin, Gavin Stoller, Simcha Steinhauer was talking about cases that generally there was, if you, for example, Gavin Simpson, got your smicha outside of the land of Eretz Israel, you could form a judge in a monetary case, but not in capital cases. Obviously, 40 years before the temple was destroyed, they could no longer preside over capital matters, even in Eretz Israel. That's for sure. But prior to that, outside of Eretz Israel, could only deal generally with monetary matters, unless they got their smecha in Eretz Israel. So it was a proper Masorah. It had to be that's where they got. It's almost like Lahavdil qualifying from Cambridge or Oxford University or one of the Ivy Leagues. Not now when it's woke, but back in the day when Harvard and Yale were Harvard and Yale. It is seen with a greater merit. And if they preside over capital cases in Babylonia, they had to have come from Eretz Israel first. So that was one aspect, that there was a superiority, and that had to be addressed before they could deal, because you had what you call municipal courts, provincial courts, national courts on the judicial circuit. But certainly there was a merit that the Gemara mentions in Israel, where the judges would get some form of Ruach HaKodesh, should the defendant deserve it. And they certainly had a higher caliber to be able to judge if they'd originally judged the case in Babylon, to know the law with maybe greater degrees of intricacy. But it's not that the ones that could judge capital cases were of a lower caliber, because they could still judge capital cases. It's just there were levels. Does that make sense? Both aspects apply. It's a good question. But what they're saying is, if it was a Babylonian judicial court, not a Babylonian secular court, but a Sanhedrin that convicted this person of a capital offense, and that court relocated to Eretz Israel because Babylonia became unsafe, they wouldn't retrial the case at all. Because, as Gavin Simpson mentioned, yes, the merit of the Israel does count for certain things, but it doesn't provide the open sort of miracle that the defendant was wishing for if the case has not changed one iota. It's only in light of the fact that it's a different court that they could say it looks natural, and therefore these judges might come to a different conclusion. So it's both interplaying. Good question. Okay.
Cool, thanks.
All right, so let's go on to another matter. So the Mishna stated, The laws of Sanhedrin applies outside of Eretz Israel as well. This is to answer Gavin's question. Where's this derived? Because the rabbis taught in a brisa. If we have a look, where's this? It's in Bamidbar, Numbers, chapter 35, verse 29. And that's exactly where it's found. It says, there will be for the laws of judgment for your generations in all of your dwelling places. So what does this mean? What does it actually mean is we learn that the laws of Sanhedrin is in effect both in the Holy Land and outside of the Holy Land. But if so, then why do you add this phrase in the pasuk in all of your gates? So that implies that courts are found only in the gates of the Holy Land, it would seem. So the Gemara makes it clear. It says, look, as far as the Holy Land is concerned, you've got to establish courts in each and every province and in each and every city. As far as outside of the land of Israel, a provincial court suffices, but you don't have to have a court in each and every city. One of the things to bear in mind is this wasn't exactly the size of Johannesburg. So you didn't have that sort of need where you have millions of people within a city. So population percentages also dictate. Does that make sense? This is mentioned in Sanhedrin and Makkos, both. Any question, guys? That's fairly straightforward. So Eretz Israel, both provincial and on a city level, but outside of Eretz Israel, provincial only. That applies, obviously, since the population wasn't, as it has exploded now, to 8 billion, and us, obviously, in the millions. So the Mishna further states, a Sanhedrin that execute, and the one opinion, the first opinion is 7 years is called a destroyer. This is according to Kevin's point. So the anonymous Tana Kama said that once every 7 years is considered extreme. Now, this is obviously dealing in a generation where people were holding in a higher level. Now, we want to know, according to Rav Elazar ben Azariah, when he says 1 in 70 years, is he talking about maybe a slightly later time period where the quality of Jews and human beings in general has dilapidated somewhat in their moral compass? Or are we saying that maybe he wants to amend the Tana of the first section of the Mishnah by saying, listen, it's not 1 in 7 years is called a destroyer. That's a bit extreme. Realistically, it's 1 in 70 years. So the Gemara is saying, is he looking to overturn the Tana of the first Mishnah by correcting him, or is he just saying, well, he's not correcting him, but he said that this is his opinion, maybe given a slightly different time period, or according to his definition of what is an acceptable amount of executions, because they're entitled to have different opinions. It's not law, it's an opinion. So the Gemara concludes, let it stand, meaning that the Gemara can't determine if it's his own opinion, and he's just saying, well, I hold it's not as extreme as that, or if he's contradicting the Tana of the first Mishnah. So the Mishnah continues. Now, there's a discussion, according to Rabbi Tarfon and Rabbi Akiva, who said that no person on the Sanhedrin, if they had been in charge, would ever have been executed. Okay? So the Gemara firstly asks, what do you think they would have done to prevent executions? Now, Gavin Stoller, you remember this because we were sitting next to Rav Simcha when he covered this ground. So as far as Rabbi Yochanan and Rav Elazar, they both say, look, they have a different approach to Rabbi Tarfon and Rabbi Akiva. They're in agreement that no person would ever have been executed, but they had a specific strategy. What was their strategy? They would have asked the witnesses to the murder, did you see if he killed a treifa, whose murder is not punishable by death, or did he kill a whole person? Can anybody answer what a treifa is?
Yeah, I actually do remember this. Sorry, Damon. I do remember this.
Yeah, go for it.
Not just the
animal.
basic
Gavin first. You go first.
I remember. No, Kevin can answer. I remember this whole issue with these different excuses, but not in detail. So it's a good refresher for me. Kevin, I'll answer it if you don't know it, but go ahead. Answer it,
Treifa
Trevor.
is an animal that hasn't been shechted properly and you can't consume it.
And
Either with a blunt knife.
that is
Okay, but
one
this is not an
definition.
animal.
Treifa, are you talking about a person or the actual
hang
animal?
on, Kev, there's a difference between an animal, a nevela, and a treifa. Okay, so a treifa has come to mean non-kosher, but what treifa actually meant is that you couldn't shecht and eat it because it was an animal that was dying due to a
Okay.
particular condition, and therefore it wasn't considered fit for consumption. Okay. And nevela is an animal that fell down, if you remember, in a bore, in a pit, and damaged itself to the extent that you couldn't shecht it because it died of unnatural means. Do you remember? So the treifa in this case is similar to an animal treifa in that it's basically a person suffering from any of the 18 specified defects that will cause him to die within 12 months. So that person is considered legally dead halachically in many respects. And therefore, his murderer is therefore exempt from the penalty of execution. Before you jump on my back, look at Sanhedrin 78a. I knew you'd jump on my back and say, but that's not fair. We learn, because it would be a logical argument. You know you can't hasten death, which is why, for example, you can't take people off life support, etc. So that causes active death. Whether or not you should put on life support, that's a completely different discussion, since nature, inverted commas, would take its course. But in Sanhedrin 78a is that if you murder this person, the defendant gets off. Now, this is a moral issue. What happens if you took away somebody's a year out of their life or 11 months out of their life? You should be maybe susceptible to the death penalty. So that entire moral discussion is not the scope of this year, but just know that it's one of the reasons that the Sanhedrin exonerate him, is if the victim was a treifa and that he was going to die within 12 months anyway. Okay. So you can see where this is going. Basically, Rabbi Tarfon and Rabbi Akiva would have asked the witnesses if they examined the corpse after the murder to see if it had one of those defects, to check that the person was dead. Rav Yochanan and Rav Elazar say exactly the same thing. Now, there is a bit of a problem with this, because the problem should be, there's a rule in Chulin saying we go by the majority. And this is a point that I brought in the shir. Do you remember, Gavin? And that is that the majority of people are not terminally ill. So how can you ask the defendants if this person is terminally ill? Because they wouldn't know. And why would you use this exceptional rule to say, well, when in doubt, assume he's terminally ill to get off the defendant? Because it's rare. It's rare that somebody's terminally ill. So how do you go after the minority percentages that this person is terminally ill? And one of the ways the judges do that is they say, look, let me put a scenario to you. He took a knife and he stabbed the victim. And the hole where he stabbed the victim could have been where the victim had a perforation in his aorta and therefore was terminal anyway. It's just his knife wound covered up the congenital defect in his heart. So do you know before witnesses, once you examined that this person was dead, after you saw the crime, that in fact he didn't have this congenital heart defect, and therefore the wound to his heart might have masked the fact that this person was going to die of a heart attack, or perhaps if he was stabbed in the neck, he might have died of a brain aneurysm. How do you know that there wasn't a clot where he was stabbed? So because the because the witnesses can't answer whether the victim had that injury, the inability to answer it means that you couldn't accept their testimony to convict the defendant. They weren't sure. The minute you're asking it as a question, is the minute that the defendants can't answer it and they're in the back foot. So there is a general principle. If you don't ask the witnesses that, you can't assume that that this person is in the minority, the victim of people that are dead man walking. But once you ask the witnesses, were you able to, without a shadow of a doubt, know this person is a treifa? And they say, well, they didn't know. Then in that particular case, since they didn't know, it's possible that he could have been. Now, bottom line, what did Rabbi Tarfon and Rabbi Akiva, what could they have done in an adultery case to avoid handing down a death sentence? Just give me a few minutes, guys, and then we actually finish the chapter. I need only 5 minutes from you, or 4 minutes. So Abai and Rabbi both would have asked the witnesses, listen, guys, did you see the equivalent of an applicator inserted into a tube of eyeshadow? So that's a Gemara in clean language. So what does that mean, guys? It means, did the penis enter the vagina? If you've got a eyeshadow or a nail polish and the applicator goes in and out, what do you think it means? Intercourse. Gemara is pretty clean, not the way I'm explaining it. So nobody's going to say they're witnesses, because how can a couple have any romantic feelings for each other when both of the witnesses are like this, looking over them to see that there was actual intercourse? It ain't going to happen. They're not going to get that close. So that's how they would have actually got the adulterers off. Now, not everybody agrees with this, because Rabbi Tarfon and Rabbi Akiva are of that particular opinion that they would have got the people off. Because the rabbis judge an adultery case in a different sort of way. How does Shmuel do it, for example? He says in the case of adulterers, the witnesses can say that they saw the couple commit adultery when they appear even to be acting in the manner of adulterers. In other words, they look like they engaged in conjugal relations. In other words, they don't even have to view it from the foreplay to the orgasm. If it looks like sex, whichever duration of time, and two witnesses can testify to it together, that's enough for Shmuel. Okay, so guys, well done. We finished the chapter. Kate said Ha'edim, it's done. We're now going to be dealing with the era Miklat. Well done, guys. Any questions?
Thanks.
I'm just saying you should or having a question.
Question.
Yeah.
The story with like sort of a treifa person you're talking about. Say the person is terminally ill. You're questioning if they kill this person who was terminally ill, and they can get off the hook because he was terminally ill.
Not the murderer, not the witnesses, the murderer. So according to Sanhedrin,
How can that be? So if someone's sick, you can go kill him.
According to Sanhedrin 78a, the job of the Sanhedrin is to get off the murderer. So if the person has a certain life expectancy left, they consider as if his life was ended. If he's got less than 12 months, Shemaim will deal with him. Shemaim will, Lance, this is the critical point. They do not get off with Hashem. But the Sanhedrin on that basis has seen the victim as a dead man walking. He's halachically dead. There's certain things he cannot do when he's in that state of terminal illness. And one of the...
This can't be the halakha, because in modern times, assisted suicide isn't allowed.
Correct. And that's why I said it's not the scope of this particular discussion. I've got this entire thing I'll try and get it from Rabbi Akiva Tatz, because I used to learn with his brother-in-law Ian Shapiro about this case of hastening death being an avera. This is exactly what came up in Sanhedrin of what we know now, compared to a murderer getting off the hook for prematurely killing somebody that's terminally ill. The main point to bear in mind here is they ask the witnesses in such a way that they cannot answer to know for sure this person wasn't terminally ill, because they're saying perhaps a puncture wound masked a genetical defect that would have rendered him dead within 12 months. And their inability to answer in the affirmative for sure that he wasn't a treifa renders the murderer off the hook. So take this
It
up.
just seems like it seems like they're playing games over here just because they have I'll call the modern terms over here, like a lefty ideology that's putting a person to death or capital punishment is wrong. It just seems ridiculous. That just causing much more crimes, the Gemara says later. Yeah,
Damon,
it
I
just
mean,
seems
agreement with you.
irresponsible of them. It
I
seems
agree.
irresponsible of these
I agree
Rabbonim. It's
with you.
terrible.
I agree with you, and I
Mm.
agree with Lance, and this is why I want to try and get together with Rabbi Kiva Tatz and try and get to the bottom of this, because this irked me even in Sanhedrin. Promise you. I'm in
Yeah.
agreement with you guys. Like, why play games? Why have this thing where you kill the person inadvertently through the barley treatment if you're not going to do it through the Sanhedrin? But at least I did address that properly. So I'll address this as well. I'll address it as well. It's bugging me too. I agree with you guys. Anyway, this year was given over accurately in terms of why it bugs me. I'm going to try and work it out. I want to speak to some of the Rabbonim and see. But I share your sentiment, guys. I really do. True.
Yeah, I was just saying, sorry, I was